Hello everyone, welcome to Courts Today by Live Law, your go-to source for the latest and fastest legal updates. I'm your host Urvashi Chauhan, here to bring you daily insights into the most important developments and landmark judgments shaping the legal landscape. Whether you are following major court cases or want a quick rundown of significant decisions, we have got you covered. Let us begin with the headlines and a concise overview of the top stories, and after that we will delve into full details. In the Tirupati Laddu row, the Supreme Court has formed an SIT to probe the allegations of use of adulterated ghee. The Supreme Court has refused to review the judgment allowing subclassification of scheduled castes. The top court has refused to pass a status quo order against demolitions in Somnath, seeking Gujarat's response. Kerala Women's Commission has suggested enactment of special legislation to address issues faced by women in entertainment industry. The Supreme Court has questioned Delhi Lieutenant Governor for interfering in the MCD Standing Committee election matter. Filmmakers of the movie Emergency have informed the Bombay High Court that issues have been resolved for its release. The Supreme Court has asked Telangana DGP to file an affidavit on plugging communication gaps between prosecution and government counsel. And in the Bulandshahr moving car gang rape and murder case, the Allahabad High Court has commuted death sentence of 3 convicts to 25-year jail, saying that the case was not rarest of rare. In the ongoing Tirupati Laddu controversy, the Supreme Court today constituted an independent special investigation team to investigate allegations about the use of adulterated ghee for preparation of laddus offered as prasadam at Tirumala Tirupati temple. Saying that an independent body will inspire confidence, the court has substituted the SIT which was formed by the Andhra Pradesh government. The new SIT will consist of 2 officers of the CBI who will be nominated by the CBI director, 2 officers of Andhra Pradesh State Police to be nominated by the state government, and a senior official of the Food Safety and Standards Authority of India, that is FSSAI. The investigation will be monitored by the CBI director. A bench of Justices B.R. Gawai and K.V. Vishwanathan was hearing a batch of petitions seeking court-monitored investigation into the controversy. On the previous hearing, if you remember, the court criticized public comments made by Andhra Pradesh Chief Minister Chandrababu Naidu, and it had sought centre's view on the need for a central investigation. Today, Solicitor General Tushar Mehta said that if there is any element of truth in the allegations, then it is unacceptable. At the same time, the SG said that members of the SIT constituted by the state government are competent and independent. However, the SG suggested that the investigation of the SIT can be monitored by central government officials. The court today said that it did not want any political drama and there will be confidence if the probe is conducted by an independent body. In the next update, the Supreme Court has dismissed the review petitions against its decision that held that subclassification of scheduled castes is permissible to grant separate quotas for more backward within the SC categories. In August this year, a 7-judge constitution bench of the Supreme Court by 6:1 majority held that states can identify more backwards among the scheduled caste categories and can subclassify them for giving separate quotas within the quota. The court had clarified that while allowing subclassification, the state cannot earmark 100% reservation for a subclass. Also, the state has to justify the subclassification on the basis of empirical data regarding inadequacy of representation of the subclass. In her sole dissent, Justice Bila Trivedi had held that scheduled castes cannot be subclassified. Following this decision, several review petitions were filed against the judgment. The court has now refused to review the judgment, stating that there was no error apparent on the face of it. The Apex Court has today sought response of State of Gujarat on a contempt petition alleging illegal demolition of Muslim religious and residential places by authorities at Gir Somnath. However, the court refused to pass an interim order of status quo with respect to the demolitions. A bench of Justices B.R. Gawai and K.V. Vishwanathan was hearing a petition filed by a trust representing the Patni Muslim community of Prabhas Patan. Senior advocate Sanjay Hegde, appearing for the trust, submitted that the issue relates to structures which date back to 1309. In the notices issued to the parties, he said there was no mention of any demolition. He said that actions of the authorities were against the Supreme Court's order from 17th September, which directed that there should be no demolition without prior permission of the top court. He further informed that about 5 dargahs, 10 mosques and 45 houses spread over an area of 57 acres were facing the threat. He also placed reliance on the recent order of status quo passed by the Supreme Court on Sonapur Demolition Drive in Assam. Solicitor General Tushar Mehta, representing the state of Gujarat, argued that demolition drive is allowed under the exception set by the top court in its September 17th order, which permits removal of encroachments on public spaces and land near water bodies. He explained that the land in question in this case is government-owned and eviction proceedings began in the year 2023. Notices were issued and the parties involved were given a personal hearing. Despite appealing to several authorities, including the Waqf Tribunal, they received no relief. When Senior Advocate Hegde requested for a status quo order, the SG pointed out that the Gujarat High Court yesterday passed a detailed order declining to direct status quo against the demolitions in the area. Though Hegde pressed that properties did not fall within any of the exceptions and voiced an apprehension that by the next day of hearing, the subject properties may be raised down and status quo of the whole area changed. But the bench declined to grant the interim relief and posted the matter to 16th October. The court did clarify that if the authorities are found to have acted in contempt of the court's order, then they will be held liable to restore the properties. And now let me tell you, the Kerala Women's Commission has filed a counter affidavit before the High Court suggesting enactment of a new legislation called Kerala Entertainment Industry Equality and Empowerment Act to address the issues women face in the entertainment industry. The state government has also filed an affidavit before the court suggesting formulation of a new film policy in Kerala. The suggestions regarding the new legislation were placed before the special bench of Justice A.K. Jayasankaran Nambiar and Justice C.S. Sudha, which has been constituted to hear matters connected with the report of Justice Hema committee. During the previous hearing, the court pointed out the lacunae in the POSH Act 2013, stating that it does not address specific issues faced by women in the entertainment industry and suggested enacting a special legislation. The Women's Commission has submitted that the special legislation could encompass women from diverse fields like music, film, television, theatre, circus, visual arts and fashion to ensure that they receive equal opportunities, protection and respect. The Commission also submitted a layout of the special legislation before the court and pointed out that there must be compulsory registration of all members and stakeholders within the entertainment industry to promote a fair and equitable working condition for all. Like I said, the government has also filed a counter affidavit before the court about formulation of a film policy for Kerala. It suggested that the Chalachitra Academy can conduct gender awareness programs to increase awareness and ensure the safety of women in the film industry. The High Court has directed all the stakeholders to submit their views and suggestions in this regard. The bench of Justices P.S. Narasimha and R. Mahadevan of the Supreme Court today issued notice to the Office of Lieutenant Governor of Delhi on the petition filed by Municipal Corporation of Delhi Mayor Shelley Oberoi challenging the election of the 6th member of the MCD Standing Committee. The vacancy of the 6th member arose due to the election of BJP's Kamaljeet Sehrawat to the Lok Sabha. MCD Mayor postponed the election to 5th October following allegations of irregularities by councillors. However, the Delhi Lieutenant Governor V.K. Saxena overruled this decision and directed that the elections be held on 27 September. The election was held on 27th and won by the BJP. The Delhi mayor then filed a petition claiming that the standing committee election was held on the basis of the directions of the LG and the municipal commissioner and IS officer convened the meeting. As per her, this was illegal as only the mayor of the MCD can decide the date, time and venue for corporation meeting where the standing committee election takes place. Today at the outset, senior advocate Sanjay Jain, appearing for the Delhi LG, raised a preliminary objection to the maintainability of the petition, saying that the challenge can be raised only in an election petition. The bench replied that though it was also initially of the view that the Article 32 petition was not maintainable, there were some serious issues which require consideration. The court questioned what the tearing hurry was in holding the elections in the absence of the MCD mayor and raised concerns about the LG's reliance on Section 487 of the DMC Act. Let me tell you, this provision grants the LG authority to issue directions regarding conduct of municipal elections in Delhi. It allows the LG to appoint officers to oversee the election process, ensuring that elections are conducted fairly, especially in situations where there may be disputes or a lack of leadership. Raising serious doubts about legality and validity of LG's powers, the bench said that Section 487 is an executive power and should not be used to interfere with legislative functions. It further raised concerns about the impact on democracy if such interferences continued. While posting the matter after 2 weeks, the bench directed that elections for chairperson of the standing committee should not be held in the meantime. The Bombay High Court today continued hearing the plea filed by Zee Studios seeking a direction to the Central Board of Film Certification to issue a certificate for release of the film Emergency. The co-producer has contended that the censor board had initially granted an e-certificate and had also intimated actress Kangana Ranaut about the same through emails. However, it refused to hand over the hard copy of the certificate, citing various objections to the film raised particularly by the Sikh community. The High Court was today informed that the makers of the controversial film have worked out the issue with regards to the cuts and edits to be made so that it can be released for public viewing. A division bench of Justices Burgess Kulabawala and Firdosh Puniwala was informed that after communications between the Central Board of Film Certification, Zee Studios and Manikarnika Film Productions owned by Ranaut, the issue has been worked out. Senior advocate Sharan Jagtiani for Zee Studios told the judges that the makers will need at least 2 weeks' time to comply with the changes suggested. The judges were further told that after the compliance, the board would verify the same and issue a certificate for the film to be released. Accordingly, a prayer was made to dispose of the plea filed by Zee Studios and the judges agreed to the same. In the next update, the Apex Court today instructed Director General of Police of Telangana to submit an affidavit. The affidavit should address how to improve communication and fix any gaps between the state's legal counsel and prosecution when it comes to accessing information about criminal cases in court matters. The court today expressed that there is a recurring phenomena witnessed from the state of Telangana where there is often miscommunication between the prosecution and Telangana Government Council relating to information about criminal cases. The bench of Justices Rishikesh Roy and S.V.N. Bhatti was hearing a plea filed by Bahujan Samaj Party leader Vijay Yadav, who had moved the Apex Court last year against alleged criminal prosecution by the then Bharat Rashtriya Samiti-led government in Telangana after Yadav made a political switch from BRS to BSP. When asked about specific filing dates of the charge sheet, the state of Telangana was unable to prove this information. The court expressed surprise at the lack of knowledge and summoned the DGP. Today, the DGP appeared virtually and submitted that there was a lapse on the part of the officers for not mentioning the dates on the charge sheet and informed the court that proceedings would be initiated against the concerned officer responsible for the lapse. State of Telangana's counsel also apologized to the court and submitted that there was a miscommunication and the same will not be repeated again. The bench concluded by stating that another reason for requiring the officer's presence was that the officer's argument appeared to follow a political directive. It noted that FIRs were being accepted and charge sheets were being filed, which is why the court had requested the date of the charge sheet, the time taken to file it, and the line of investigation followed in the matter. And lastly, the Allahabad High Court today commuted the death penalty to 25 years of imprisonment without remission imposed upon 3 men for gang rape and murder of a 17-year-old in Bulandshahr district of the state. As per the prosecution's case, in January 2018, convicts namely Zulfikar Abbasi, Dilshad Abbasi and Malani forcibly took a 17-year-old girl into their car, and in the moving vehicle they committed rape with her one by one. When the girl started crying, they strangulated her with the help of a dupatta that she was wearing around her neck, and after that her dead body was thrown in a drain. In March 2021, a POCSO court in Bulandshahr sentenced them to death by hanging, observing that their crime had scared people and parents became apprehensive of sending their girls to school. Hearing their appeals and reference made by the trial court for confirmation of the capital punishment, the High Court bench of Justice Arvind Singh Sangwan and Justice Mohammad Azhar Hussain Idrisi, on reappreciation of the entire evidence, noted that it was not a rarest of the rare case where the death penalty could be awarded. The court upheld their conviction for the crime, but as far as their sentence was concerned, it observed that it was not a case where death penalty could be awarded. The High Court considered some mitigating circumstances such that the accused have no criminal history and have their families in support, that they are aged about 24 years, and the possibility of reformation and rehabilitation of the appellants in the society cannot be ruled out. For more details on the cases that I mentioned, visit our website at www.livelaw.in. Stay ahead with quick legal updates only on Live Law. Please do not forget to like, share and subscribe to our channel. You can support us by donating through the thanks button at the bottom of our videos or by becoming a member at just 89 rupees per month.